in the first degree as submitted in instruction number 6. We assess and declare the punishment for unaliving in the first degree at imprisonment for life without the possibility of probation or parole. Welcome back, M. Welcome back, Weeds. Welcome back, everyone. Thank you guys so much for liking that stream. I appreciate you guys. So he was found guilty. Verdict as to count 2, we the jury find the defendant Nicholas Godejohn guilty of armed criminal action as submitted in instruction number 10. Note, unless you found the defendant guilty of in the first degree as submitted in 6, you may not complete this verdict finding the defendant guilty of armed criminal action as submitted in instruction number 10. Okay. So he was found guilty of this and this, which we know, right? This looks like a sentence and judgment. Okay, we will read what it says. Okay. State of Missouri versus Nicholas Paul Godejohn. The defendant appears in person with his attorney, Dwayne Perry and Andrew Meade. The state appears by assistant prosecuting attorney, Nathan Chapman. The court finds the defendant was found guilty on 11/16/2018, and he received a copy of the SAR. Okay, and judgment against the defendant pursuant to blank for the Crime Victims Compensation Fund of $68. Probation is denied, and defendant is ordered committed to the custody of Missouri Department of Corrections and Human Resources / Sheriff of I'm looking down here, Greene County. The sheriff is ordered to transport forthwith with extra guard if necessary. So there's no probation, there's no parole, there's none of that, and he's owing a $68 fee. Okay. All right. So this is the orders to assistance of counsel and bond of appeal based upon an examination of defendant under oath after final sentencing herein and after defendant was advised of the right to proceed under Rule 24 or Rule 29. The court finds there's no probable cause to believe that defendant has not received effective counsel before sentencing. The court appoints the public defender to represent him. The court authorizes the filing of a notice of appeal without the necessity of a filing fee and allows the appeal to proceed in forma pauperis. If a notice of appeal is filed, the court reporter is authorized to prepare the transcript on appeal without the necessity of a deposit. Okay. All right. Cool. All right. This is advice of rights upon conviction. This was signed by Nick. It is my duty to advise you of your post-conviction rights under Supreme Court Rule 24. A person who is convicted of a felony may seek relief from this court if he claims either that the conviction or sentence violates the Constitution or laws of the state or the Constitution of the United States, or that this court, when imposing the sentence, was without jurisdiction to do so, or the sentence imposed was in excess of the maximum sentence authorized by law. Rule 2429 provides the only way by which you seek relief for the above claims. I am now providing you a copy of the rule. There is a criminal procedure form 40 for you to use in filing this motion. That form is available for you at no cost at the courthouse. Okay. You must understand that any motion to vacate, set aside, or correct the judgment and sentence under this rule must be filed within 180 days. If an appeal is taken, it must be filed within 90 days after the mandate of the appellate court. Okay, if you file this motion, you shall include every ground known to you for vacating, setting aside, correcting the judgment or sentence. Okay, failure to file the motion within these time limits, okay, gives a complete waiver of any right you may have. There's no cost for you to file this motion. Okay. So these are just telling him his rights. You can appeal, yada, yada. Okay, so this shows the judgment. We all know what he was charged with. It says here, life without parole. Yikes. Okay, life imprisonment without eligibility for parole. So he can never get out of jail. Okay, to run concurrent with each other in any existing. And the second charge, he got 25 years. And that runs concurrent with each other in any existing. Okay, so we know his charges now. If no one knew his charges, we know. Okay. And he's to pay $68. Okay. Okay, we read basically all of that. That's just the legal paperwork there. If you guys are just joining, make sure to hit that like button. I appreciate you guys so much. Okay, now we saw this one. We just read this one. I don't know if it's revised, but we just read this one. Let's see here. Okay, and here is his motion to vacate. So he was arrested and placed in this jail. Can't really read it. But then his sentence was imposed in Greene County. Okay. All right. So he was delivered from this Potosi Correctional Center to Greene County Circuit Court. Okay. He did appeal. He appealed to the Southern District Court of Appeals. Okay. Affirmed on 6/10. Okay, state concisely all the claims known to you for vacating, setting aside, or correcting your conviction or sentence. Ineffective assistance of counsel for failing to investigate and present mental health evidence from appropriate expert. Ineffective assistance of counsel for failing to object to testimony from the state's witnesses to the state's. Wow, they wrote all that together. And to properly preserve issues for an appeal. My attorneys did not investigate and hire appropriate mental health experts and did not present such evidence at trial. I will call expert witnesses and provide records. My attorneys did not object to witnesses' evidence and testimony at trial and at pretrial hearings and did not investigate and call witnesses in my defense. I will present evidence from witnesses to support my defense. So he did file an appeal, and it seems as if the reason for the appeal being filed was there wasn't enough mental health evidence and the lawyers weren't really doing much from what I could read here. And I did watch his trial and they weren't doing much. They weren't objecting. They didn't really seem to care. You guys, can you guys see, or am I blocking it? Am I blocking it? Hang on. His lawyers didn't really seem to care. Honestly, I'm not gonna even hold you there. His lawyers didn't give a damn. Can you guys see me still? I don't know if you guys can see me still, but they're asking if he has any other petitions. He says no. And he says yes to the last one. Any other petitions or applications in this or any other court? Yes. Okay. And that petition was application for transfer to Missouri Supreme Court. Okay. Denied. Okay. Okay. Nothing here. So it asks if he was represented by an attorney. He says yes throughout the whole trial process. And he gives the names and address of those attorneys. And he tells when they represented him. Okay. Okay. Did Nick write this? I'm not sure Nick wrote this. Did Nick write this? I'm having a hard time understanding because this does not look like his handwriting to me. It really doesn't. It doesn't. I'm currently an inmate in the Missouri Department of Corrections and have no funds to hire an attorney for my post-conviction case. Okay. Okay, we just saw this. They have a lot of duplicates in here. I don't know why, but I don't know if they had to amend things, but that's an exact duplicate. This document that we just went over was the motion to vacate. Okay. Okay, this is just a receipt that they did enter that motion to vacate for Nick. Entry of appearance. Okay. A 30-day extension to file. What was that? A 30-day extension to file an amended motion. This is a lot of court jargon in here as well. 30-day extension granted. Okay. Okay, so it's a lot of court jargon in these as well. Motion for 30-day extension of time. Okay. Those things aren't really important. These aren't really important to us. Okay, they had a deposition of Dan Glidwell. Okay, not really important to us. This is a subpoena. Has chat stopped? I don't think so. They're just not talking. They're not talking. They're probably listening. I don't know. Just type in chat to me, Jay, and I'll let you know. It hasn't stopped. Just type a bunch of things. Hit that like button. Yep, they're listening. So we've just gone through a bunch of court jargon in the beginning, like 50 pages. There's a lot of pages that repeat. We're reading the FOIA if you're just joining us. The first 50 pages aren't much juicy stuff, as you guys like to say, but it is basically explaining their charges. It gives details about the witnesses they use. It gives details about the attorneys. It gives details about Nicholas's post-conviction case, his appeal, his reasons for appeal, which those things could be important depending on who you ask from what angle. Are dupes normal or is this unprofessional? I honestly saw one of the dupes had amended on it. So maybe they're amendments, but a lot of these are just like photocopies of the other. Okay, so subpoena. Dan was subpoenaed. And I want to ask you guys a question because I know you guys are listening. What the hell did I just do? Oh my God. Okay, just ignore that. Wait, just ignore it, okay? I don't know how I did it. It was an accident. Okay, so when we talk about subpoenas, Order to appear. A subpoena, what I've always known it as, is when you get subpoenaed, you have to appear in court. Hey, Lindsay, when you get subpoenaed, you have to appear in court. You don't have a decision and to say, Judge, I might come and testify. Your ass has to be there and your ass has to be square. So my question to you guys is, before we read this part of the FOIA, right? Why would this court demand Dan to testify on behalf of Nicholas P. Godijon? Dan was there to testify on behalf of Nicholas Godijon. And he didn't have a choice. He was commanded. It says here, you are hereby commanded. Let me get my, here. You're hereby commanded to testify on behalf of Nick, to give depositions. Okay? And this is the attorney that requests. So why? I know this looks a mess, but why? Why did they need Dan to be there? Lindsay says, because he is the only other person who was still alive that knew her well before her mother's passing. Okay. That's good. If you guys are just coming in, make sure to like the stream. This is a motion for order for disclosure of evidence seized by the state and admitted at trial. Okay? Comes now moving and through undersigned counsel. You guys can't see my big ass head on. And respectfully request this court order the state of Missouri grant access to move-in for the purpose of inspection of a Canon digital camera and memory card. I didn't know about a Canon digital camera and memory card. Am I just lost? I thought they were doing all that over the web, over the webcam. Okay, all right. By the state and admitted as evidence in the underlying criminal case and in support thereof of states as follows. Okay, multiple items seized from Movent's Wisconsin residents were admitted at trial. One such item, a black Facebook backpack and its contents, were admitted. So we have a backpack. Contained within the backpack is a Canon digital camera with a 4 gigabyte memory card. To counsel's knowledge, the contents of the camera and camera memory card were never inspected. Due process requires post-conviction counsel be effective and raise all claims. Martinez versus Ryan, claims not raised within a motion for post-conviction relief are deemed to be waived. Okay. All right. Okay. Counsel needs to inspect the contents of the Canon digital camera and memory card. In order for them to investigate and raise all claims, they must look at that memory card, okay? So they're basically asking the court for access to that memory card and stuff, okay? Jenny Young signs off on it, good to go. Good to go. Signs off on it, good to go, right? Okay. Now, so these are suggestions in opposition to Mobit's motion for court order for the disclosure of evidence seized by the state and admitted at trial. Okay. Comes now respondent state of Missouri and by and through prosecuting attorney Dan Patterson and for its suggestions in opposition to Movin's motion for court order in disclosure of evidence seized by the state and admitted as trial and states as follows. States Exhibit 92, a backpack and its contents were admitted at trial. Trial transcript at page 617. Among other personal property of GYPSY Blanchard, this backpack contained a Canon digital camera with a 4 GB memory card. The digital contents of the camera's 4 GB memory card, however, were not admitted as evidence during the trial, and neither the camera nor its memory card were referenced in any trial testimony whatsoever. Why not? The investigation revealed that Exhibit 92, the Facebook backpack and contents, were the personal property of GYPSY Blanchard. Movin's counsel acknowledged that the camera and the SD card from the backpack are the property of GYPSY Blanchard in an email to the undersigned stated, who? Nick's counsel. Okay. Mr. Patterson, during our evidence view yesterday, we came across a Canon digital camera with a 4 GB memory card in it among GYPSY's belongings in the black LifeSpring backpack. To our knowledge, that card was never looked at. I believe investigator Counts was going to set that aside and talk to you about getting that looked at and any content copied to us. Thank you, Jenny. Okay. During the course of the investigation of defendant's underlying case, no search warrant was ever issued for the digital contents of the camera or its memory card. Further, the state is not aware of any information developed in the investigation that would indicate that any evidence relating to this is located on the digital camera or its memory card. Be fucking for real. Why was it in her backpack then? Be fucking for real. How could the state say, we are not aware of any information developed in the investigation that would indicate that any evidence relating to this is located on this digital camera? Why would it be on her body? Why would she have it? What? Are y'all dumb? Okay. On April 20th, 2021, the undersigned responded to Movin's counsel's emails and informed Movin's counsel that the state will not conduct a search of Gypsy Rose's camera memory card because there was no legal authority to do so. It's a camera. Are y'all serious? Hey, Amy. Kathleen says, I just found 6 newborn kittens on my patio. Feral cat has been hanging around. They are cute. 1 gray, 4 black, 1 black and white. The fun starts now. I just made her a bed. They still thought she was a victim. Ain't no way. Ain't no way. Ain't no way. Ain't no way they still thought. So you mean to tell me Gypsy Rose, where did they find this backpack? Gypsy Rose had a backpack on her. And they arrested Gypsy Rose and Nick. And they found this backpack at where? At Nick's house. And they're going to say, oh, we cannot indicate that there's anything relating to this on there. That's a stretch. That's a huge stretch for me. They're saying in order to search the memory card, they would need probable cause and a search warrant. Movin asserts no legal authority that would exempt the digital contents of the camera's memory card from the search warrant requirement of the 4th Amendment to the United States Constitution. Further, Movin asserts no facts whatsoever to establish any cause to believe that the camera's memory card contains any evidence relying to the underlying charges for which Movin was convicted. Simply put, Movin's counsel is curious as to what is on the SD card and is asking the court to allow Movin to conduct a fishing expedition in violation of the... This is what they're saying they're doing at Gypsy Rose. A fishing expedition in violation of the 4th Amendment. Wherefore, respondent prays is crazy, that the court deny Movin's motion for court order for disclosure of evidence seized by the state and admitted at trial. Okay. I don't like that. Everything they did was camera. Everything they did was camera. Everything they did was camera. And it was like stowed away in a backpack. You don't find that sketchy? Like a random ass backpack? Like what else was in the backpack? Mm-mm. Something up with that camera. I'm telling you right now. Something is wrong with that camera. Straight like that. So this is what the court says. This is a court's order. After due consideration of the arguments of the counsel, the court finds that Moven's suggestion that relevant evidence may be contained on the camera's memory card is at best speculative. Although in police custody at this point, the camera and memory card were never admitted to evidence at trial and are not in the possession of the court. Since this item is the personal property. Oh, she has personal property? Oh, gosh. Of Moven's co-defendant, Moven may have remedies available to obtain the item in question. So they're saying because Nick and GYPSY have been accused of this crime, then Nick's lawyers would want that in order to throw GYPSY under the bus. That's what they're saying. Nick's lawyers' reasons for wanting to have that evidence would be to throw GYPSY under the bus solely and not get the real truth of the facts. However, the court does not find that it has authority to order the state to conduct a warrantless search of the memory card or release the property to Moven's counsel for examination. So the motion for disclosure is denied. I don't know what's going on with my highlighter. I don't know what's going on with my highlighter. I have no idea what's going on with my highlighter. If you're just joining, make sure you like that stream. I don't appreciate how, the judge ruled, huh? Wait, what happened? Oh, I'm sorry, y'all. I'm talking and reading the comments at the same time. Sorry. I forgot there's multiple Lindsays in here, but something's fishy about that. Something's fishy about that to me, because in my opinion, if you're a judge, that's just fishy. That's very fishy. Like the state is, I understand. The state has a goal. The state's goal is to find Nicholas guilty of the two charges that they brought against him. That is the state's goal, to find him guilty. So in the state's mind, something on that camera could exonerate him. So we have to do everything we can to not let his lawyer see what's on that camera. We screw the camera. There's probably nothing on it. The state's job is to make sure Nicholas is in jail. So they're looking at a camera in GYPSY's backpack. Wait, what? We don't want to see that. They don't need to see that for sure, because they're going to use it. She said the pain pills were in her backpack. Unbelievable. Yeah. Unbelievable. I don't know where the pain pills were. But I don't know where these magical pain pills were. She said it like one time, like once to the officer that was investigating her. She said it to him one time about the pain pills, and then she said it to Nick in the text messages. I need to go get my medicine, something like that. But I don't remember her saying my pain medicine or something. I don't know. I have no idea. I have no idea. But that's kind of sketchy. The camera shit is sketchy to me. Okay. Okay, so this is the vacation motion, all right. The case number and the offenses being tried, the sentencing dates. He did have an appellate proceeding. And this is why he wanted to correct his sentence here. We did talk about this. Ineffective assistance of counsel, failure to investigate and present evidence from a qualified neuropsychologist specializing in autism spectrum disorder, Asperger's, and guilt phase to support a diminished capacity defense. Nicholas Godejohn was denied effective assistance of counsel, a fair trial, due process, and was subjected to cruel and unusual punishment in violation of his rights under the 5th, 6th, and 8th and 14th Amendments to the United States Constitution. Article 1, Sections 10, 18, and 21 of the Missouri Constitution, in that his trial and counsel failed to fully investigate and present evidence from a qualified neuropsychologist specializing in autism spectrum disorder to support a diminished capacity defense. Do we think Nick had a diminished capacity? Do you really think Nick had a diminished capacity? Make sure you guys like the stream for me. If you're just in here, like the stream for me, guys. We're trying to turn the stream up. Do we think Nick had a diminished capacity? I don't know. I don't know if I can call what Nick was going through or what GYPSY was going through a diminished capacity by any means, due to the sheer premeditation, due to the sheer year or so of premeditation. How can they have a diminished capacity? That's my opinion. You guys may feel differently. I feel like diminished capacity would be more like in the moment type of thing. Like your capacity was diminished for a moment, not for a year or 2 or 3 or 8. You know what I mean? I do. If he couldn't get a job, he believed he was like on a basis of diminished capacity for a long period of time. Was he being treated currently by a healthcare professional? No. Was he taking medication? No. But when we think about a completely diminished capacity, I don't see Nick. I just don't. I don't. No, I don't think, because when you say diminished, I'm thinking diminished. I'm thinking if your capacity is diminished, you're not able to sustain the same behaviors for a year straight. Like, I'm thinking that. Should they have had a neuropsychologist? Yes. Yes, they should have had a neuropsychologist. I completely agree. They should have had someone who knows his situation. They should have had someone who knows his situation specifically. I think his counsel failed him in that area to where they couldn't get someone to effectively explain to the judge who this man was to start off with. But I don't think that neuropsychologist would have ever supported a diminished capacity defense. That's my opinion. That's my opinion. I don't know. I'm not a neuropsychologist. I'm not a autism spectrum disorder specialist. I don't know what constitutes diminished capacity or not when it comes to those things. But I do think that I definitely do think that he knows right from wrong. He knows right from wrong. He knows that he wants GYPSY to be his girlfriend. He knows that he wants GYPSY to live with him. He knows that he wants GYPSY to love him. He knows all of these things, right? So when we start talking about diminished capacity, those things don't matter, in my opinion. So, yeah. Into the Weed says he definitely knew right from wrong, right? Yeah. Socially, he was inept. Nick should have been in a program to teach him how to take care of himself or get a job that he can do. I agree. I definitely do agree with that. I tell the story a lot because there was this girl who had, I think it was, she had autism, or I think it was Asperger's, that I went to high school with, and everybody teased her, everybody picked on her. We don't know if Nick went through those things because they are kind of outcasts in high school, middle school, because of some of the things or the behaviors they may have. But you just have to, you can't judge. That's the biggest thing. You can't judge. And to be completely honest, I've seen her at school engage in some self-harm behaviors. I've seen this because somebody got her to the point where she was so frustrated that she got to the point of like self-harming behaviors, if it was like scratching herself or whatever the case may be. And it was true, you could tell it was truly ticking her off, and there was nothing she could do about it in that moment. There was nothing she could do about it in that very particular moment. If somebody did something to piss her off, it went to a darker place for her. But that wasn't all day, every day. That wasn't all day, every day. She didn't plan it for a year. This was something in the moment. Yes, I saw her capacity diminish at times, but it's hard to say that for me. For me, it's hard to say that because I've seen, I would even consider us to be friends on a level, because kids didn't want to work with her. Nobody wanted to work with her. They all the popular kids looked at her like she was gross. And I was the only person that would work with her, right? Just out of sheer, like, y'all are like, I would always look at my classmates who judged her like, y'all are just disturbing people. And my teacher would come up to me and my teacher would thank me. Thank you for working with her. Thank you. And I'm like, you don't have to thank me. She's just a normal person. All they want to do is be treated normal. That's all I'm saying. And Nick is no different. He wanted to be treated like a normal guy too. So for us to go as far as to say that, I don't know. But I will continue here. You guys continue talking in the comments. I'm reading everyone's comments. They also say that counsel failed to exercise the customary skill and diligence that a reasonably competent attorney would have exercised under similar circumstances. Nicholas Godejohn was prejudiced as a result, in that counsel had not been ineffective. There is a reasonable probability that he would have not been convicted of murder and armed criminal action and would not have been sentenced to life without probation and parole in 25 years. So if he was not sentenced to this, what would he have been sentenced to? Because there is a victim, there is someone that's gone. You know what I mean? So what are you just going to plead insanity? I mean, diminished capacity. Counsel was aware, or should have been aware, that prior to trial, Nicholas was diagnosed with autism as early as second grade and with Asperger's syndrome in high school. Counsel was aware, or should have been aware, that autism spectrum disorder refers to a group of complex neurodevelopment disorders characterized by repetitive and characteristic patterns of behavior and difficulties with social communication and interaction. Counsel also was aware, or should have been aware, that the symptoms of ASD are present from early childhood and affect daily functioning. That is true. Counsel was aware, should have been aware, that there are structural brain differences in someone with ASD compared to those without ASD. Counsel was also aware, should have been aware, that for 3 years prior to the offense, Nicholas Godijon and GYPSY Blanchard engaged in an increasingly intense online relationship, which includes explicit online chats and videos made by GYPSY and sent to Nicholas. Okay, so what is the defense saying here? What are they saying? Okay, the reason why this kind of ticks me off is because, hang on one second here. Let me just get this. Okay. You're talking about all the things his trial counsel failed to do. Why did they fail to do it? Right? Why did they fail to do it? How is it going to be different the second time? You know what I mean? You're saying all these things that they missed the mark on. You're saying that they didn't have a doctor. You're saying that they didn't treat him appropriately due to the disorders that he had. What's going to be done differently the second time? Why wasn't it done the first time? That needs to be addressed, I feel like. Counsel was aware, or should have been aware, that there are structural brain differences. Oh, we read that. Okay. All right. Counsel elected to put forth a diminished capacity defense at trial. Once that decision was made, counsel had a duty to retain a competent, qualified expert with substantial practical experience in evaluating and treating individuals with autism, such as Dr. Theodore Wasserman, and to investigate and present evidence on how Mr. Godijon's specific mental disease and defect and the facts of the case support a diminished capacity defense. Counsel's failure to do so fell below the standard of care that a reasonably competent attorney would exercise in similar circumstances. Now, I do agree with that. I definitely do agree with that. His counsel was bad. He had bad counsel. He did. They didn't really care. Right? They didn't really care. So they did just enough, you know? They felt like they did just enough. Right. Hey, Lindsay. You love the questions I asked? Thank you. I definitely okay. If you're just joining, make sure you hit the like button. We're going through the FOIA. We're on Nick's defense, and we're kind of talking about, you know, why his counsel was so bad, and was his capacity really diminished? Did his counsel do enough, or should they be required by law to run it back, in a sense? I don't think his counsel did well, right? They didn't do well at all. They did just enough to pass the damn time. And I feel like a lot of state attorneys will give that type of representation in a case like that. You know, that's just what I feel. And I don't understand if they're coming out in the appeal and saying, oh, they should have had this type of lawyer, they should have had this type of doctor. They should have had this person speaking. They should have done this. They should have explained this. That should have been discussed the first go around. Why are you appealing to tell us what you should have told us the first go around? That's how I feel about it. But anyway, evidence that the defendant did or did not suffer from a mental disease or defect is admissible in a criminal prosecution to prove that the defendant did or did not have a state of mind, which is an element of the offense. This is commonly known as a defense of diminished capacity. When first recognizing the diminished capacity defense, the Missouri Supreme Court defined it as proof of mental derangement. Let's see here. This is diminished capacity, guys. Now we're going to talk about if we think this fits, okay? Proof of mental derangement short of insanity as evidence of lack of deliberation or premeditated design. And that's what I just spoke on earlier, okay? Proof of mental derangement short of insanity as evidence of lack of deliberation or premeditated design. In other words, it contemplates full responsibility, not partial, but only for the crime actually committed. In Walk Up, this is another case, I guess, the defendant was convicted for his girlfriend. The trial court excluded the defense's attempt to present expert witness testimony that would have made it less likely that he would have deliberated before doing this. What? The Missouri Supreme Court reversed and held that the defense's expert proposed testimony that the defendant suffered from bipolar at the time of the offense was logically and legally relevant to the issue of whether the jury should believe the state's evidence that he acted with deliberation. It was definitely. I'm gonna just let you guys go on that one. How long is this part? Like, I feel like it's damn near 80 pages. Goodness gracious, y'all, we're gonna be reading this for a year. Oh my God. Okay, hang on a second. Okay. All right, so there. I think it's important though. This is very important because a lot of people have been talking about this. A lot of people have been talking about this recently. It should be an ACLU case. Hey, Angela. Yeah, this is deep. This is heavy stuff because you could see both sides of it. You can see both sides of what they're saying here. The walk-up court also held that the notice provisions of Section 552 did not apply to diminished capacity evidence under Section 552 at 756. For purposes of a diminished capacity defense, the terms mental disease or defect, they have those in air quotes, include congenital and traumatic mental conditions as well as disease. Prior to trial, counsel retained a clinical psychologist, Dr. Ken Franks, to evaluate Mr. Godejohn for competency. Dr. Franks found Mr. Godejohn competent to stand trial and provided trial counsel with a report to that effect, and also diagnosed Mr. Godejohn with autism spectrum disorder level 2, requiring substantial support with accompanying intellectual impairment. This report was provided to trial counsel on September 28, 2016. On October 11, 2016, trial counsel informed the court that the defense in this case would not be in GRI, but that Mr. Godejohn did not have a state of mind, which is an element of the offense deliberation in this case. I don't know. Okay. Okay. So they must have said that during the trial. Like, oh, he didn't have a state of mind. Okay. The record reflects as early as October 11th, it was the intent of counsel to put forth a diminished capacity defense. Since counsel knew that Mr. Godejohn had been diagnosed with autism as a child and Asperger's in high school, and that Mr. Godejohn's relationship with GYPSY Blanchard was an important aspect of the case in regard to whether or not Mr. Godejohn was able to deliberate at the time of the offense, it was incumbent on counsel to investigate and present evidence from qualified neuropsychologists who had expertise and experience in the area of autism spectrum disorder. Instead, counsel chose to keep Dr. Franks on the case and call him to testify to Mr. Godejohn's mental disease or defect and his inability to deliberate at the time of the offense at trial. Okay, so this was just a regular clinical psychologist that he talked to. It wasn't like a specialist, but it was still a clinical psychologist who's, I don't know, a psychologist? It wasn't like a doctor? I'm confused. A clinical psychologist is not someone who diagnoses people, right? Or are they? Am I wrong? If I'm wrong, let me know. Because, hang on, we'll look it up. Oh, they can diagnose. Okay. They can diagnose. Okay. I thought psychologists were more of like talk therapists there. I'm reading y'all's comments. Sorry, y'all. They can diagnose but not prescribe medication. Okay. Oh, yo, you guys see my computer. I don't know if you guys can see it. Okay. So we're just basically looking at that. I'm not trying to down. No. You know who's gonna know? Bree. Bree's in school for this. So she would know. She would be the one to know. Bree would be the one to know. Bree, so you tell us in your opinion, because Bree is actually in school for this right now. I'm pretty sure she told me earlier that she was in school for clinical psychology. So, do you think, we're going to ask Bree. Bree's going to know. She's the expert in the room. Do you think that a clinical psychologist, Dr. Franks, was fine to sit on this case? Bubble said she has a master's and social work and they cannot diagnose autism. People just typically go to the pediatrician first, right? Right. I don't know. I went to a psychologist and they said that I'd have to go to a specialist. Hold on. Hold the hell. I know y'all are lying. Who is this doctor? Who is this? Okay, hang on. Hold up. So they wait a minute. So what we're finding out right now At first I was like, they had to have someone there to assess him properly. That doesn't stop my feelings about the diminished. That doesn't stop my feelings about the diminished capacity defense. Okay. It doesn't stop my feelings, but you have to be fair. Who the hell is Dr. Kent Franks? Who is that? Who is that? Where did y'all get him from? There are people in the comments telling me that he can't even diagnose autism. So you guys went and found the cheapest doctor on the block to just come in. You didn't get a specialist to tell the court what was going on with Nick. Hang on a second. We're going to find out who he is. Hang on a second. Dr. Franks. Where are we at? We're in Missouri. Okay. Dr. Franks. We don't have his first name. Do we have his first name? Kent. Yeah. Spotlight. You looked up, baby. Okay. And we're going to put clinical psychologist. Oh! Do you guys not want to see? I can drag it over here and I can look. I won't show you guys. I'm going to just look. I'm going to look. If you guys want to see, then let me know. But I won't pull them up if you guys want to see. Wow. Okay. So he works in forensics. He works in forensics. Okay. He's been retained as an expert witness in the field of clinical psychology. He's been involved in cases related to criminal law, personal injury, administrative law, etc., etc. So he is an expert, they say. He is an expert in the field of clinical psychology. That's all I need to see. I'm not gonna even hold you guys. All I need to see that, okay, 33 years of experience in forensics, clinical psychology, and has testified as an expert on multiple cases. That's what they say. That's what they say here. He got his PhD from California. He got his MA from California and his BS from Southwest Missouri. So it seems like they went and got. We could see his testimony. We can go, if you guys want to look it up, his testimony is online as well. Okay. So, his testimony is online. So, hang on one second here. This is if you guys want to watch it on, you guys can watch it on your own time. You can watch it because I don't want to get sidetracked. But this is Dr. Kent Franks testifying. Okay. Y'all can tell me if y'all feel like he's qualified. From what I read online, I think I can stand by that. You're welcome, Mew. You're welcome. You're welcome. You are welcome. We're going to go a little bit further today because I do have videos to do, shorts to do, all that good stuff. I'm enjoying doing this, and it's opening up a really good conversation. But we're going to be live the entire week breaking it down. This is 417 pages of FOIA. We have a lot to get through. Please know that Nick's case set precedent. Another Nick could be hornswoggled by a mastermind. He didn't get proper representation in court. I agree with you. I feel like his lawyers were quite lazy. When it came to exposing the facts. It almost seemed as if they didn't want Nick to be found not guilty, or they didn't want it. That's the energy they were giving. They weren't objecting. You didn't see much of a fight from his lawyers, and when you get the lawyers provided to you by the state, they really don't have a lot of fight in them. When I was in high school, we would go and shadow lawyers and different things like that, internships. The private paid lawyers are so much happier. They're so much happier. You see the private paid lawyers, the ones with all the money and all the, like, they have the nice cars and all this. And then you see the public defenders, they're walking in, coffee all on their shirt, walking up to they literally walk up to the inmates in court, and they're just talking to all of them. It's like very draining, I feel, is like, for them. So I feel like in a sense you get what you pay for. You don't pay at all. They just do just enough. They do just enough to not be called negligent. And I feel like they didn't fight for Nick at all. They didn't want to. That's my opinion. But I feel as if, and we can put a spin on it. I also feel as if Gypsy Rose would have had a public defender, she would still be in jail. Right? If Gypsy Rose had the same lawyers Nick did. No good. Clink, clink. Locked up. So the lawyer has a lot to do with it. The climate has a lot to do with it. Whoever gave Gypsy a plea deal should be under the jail. Yeah, Gypsy got lucky. She got lucky. She got very, extremely lucky. That does not happen to anybody. You don't just get to skate in 8 years after doing that. No. What? She knew she was not going to trial. She knew it. As far as I'm concerned, that's a slap on the wrist. All right, let me continue reading a little bit here. Probably going to read a couple more pages. The record reflects that as early as October 11, 2016, it was the intent of counsel to put forth a diminished capacity defense, since counsel knew that Mr. Grody John had been diagnosed with autism as a child. Wait, we read all this. We read all that. Okay, next page. At the pretrial hearing on October 11, 2016, the prosecutor objected to the defense calling Dr. Franks as a witness to support a defense of diminished capacity, and argued that he should not be excluded for late endorsement because Dr. Franks' report did not mention anything about the defendant's ability to form the mental intent required to commit the crime. Judge Holden informed trial counsel that he wanted to hear the testimony of Dr. Franks as part of his decision on whether or not Dr. Franks' testimony would be included at trial. A hearing was set to hear defendant's offer of proof on Dr. Franks for November 30th. On November 30th, an offer of proof hearing was held on whether or not Dr. Franks could testify at trial. During the hearing, the court asked the state whether or not they thought Dr. Franks was an expert. Mr. Patterson answered, "I think in this particular case, there are grave issues with that, and his testimony is more likely to mislead the jury given his lack of knowledge on the specific topic he's been called to testify about," right? So while a clinical psychologist, while very educated, while an expert in many rights, was Dr. Franks an expert on individuals with autism spectrum disorder? At the close of the hearing, the state argued that Dr. Franks was not qualified to render an expert opinion on the issue of diminished capacity. Mr. Patterson stated on the record that Dr. Franks does not know what deliberation means under Missouri law and that he was not qualified to testify as an expert in regard to a diminished capacity defense because Dr. Franks was simply not qualified on the issue and does not understand what he is talking about. Okay? Dr. Kent Franks was called as an expert at trial, and the defense case in chief, Dr. Frank's CV, was placed into evidence as Defendant's Exhibit A. Dr. Franks does not have any is crazy, practical experience or training in evaluating or treating individuals with ASD and has not published any articles or books related to ASD. When testifying on direct examination, Dr. Franks was asked by trial counsel to tell the jury about his experience with people with autism. He gave the following answer. Well, it wasn't added into the DSM until 1944, and so the disorder has been known since the 1940s. But as research has accumulated, it's become much more. Clinicians are looking for it more than we used to because there's a lot more that's known about it. And so, in the work that I do in evaluating people for the courts, I've learned how to administer the test. I've learned how to identify it. I've gone to training so that to increase my knowledge about the disorder over the last 10 years. Although Dr. Frank's testimony at trial includes information parroted from the DSMV about ASD, he is clearly not an expert in the field of ASD and does not have experience in evaluating and treating individuals with ASD. Counsel knew Nicholas Godejohn had been diagnosed with autism and ASD prior to the offense and was aware, or should have been aware, of Dr. Frank's lack of experience in evaluating and treating individuals with ASD. Therefore, counsel had a duty to investigate and present evidence to the jury from an expert with substantially more knowledge and practical experience than Dr. Franks to support a defense of diminished capacity. They wrote that very beautifully. These whole 2 pages are written very well. After the offer of proof hearing, counsel knew or should have known that Dr. Franks was not qualified to testify in support of a diminished capacity defense based on Mr. Godejohn's mental disease of ASD. Dr. Franks was not an expert in ASD and therefore was not qualified to testify to his opinion of whether or not Mr. Godejohn, because of his mental disease or defect, was able to deliberate. That's a big word when it comes down to, according to this document, deliberate is a huge word when it comes down to diminished capacity. Could you? Counsel was ineffective for failing to investigate and present a qualified neuropsychologist, such as Dr. Ted Wasserman. Why do they love this guy? Like, where did he come from? Who is an expert in the field of ASD and who has substantial practical experience in evaluating and treating individuals with ASD. Had counsel hired the appropriate type of expert, a neuropsychologist with substantial expertise in evaluating and treating individuals with ASD, such as Dr. Ted Wasserman, counsel would have known that individuals with ASD are extremely susceptible to social manipulation. Hey, important. Counsel would have known that individuals with Asperger's, are extremely susceptible to social manipulation and suggestion by virtue. Social manipulation and suggestion by virtue of the following characteristics: a greater need for emotional intimacy, both romantic and otherwise, the fragile nature of their developing relationships, social impairment, empathy imbalance, which is a deficit of cognitive empathy, which is being able to understand and predict others' mental state, but a surplus of emotional empathy, which is the capacity for attachment. 5, hyper-focus on a narrow range of interest. An expert neuropsychologist specializing in autism spectrum disorders would have explained to the jury at trial how these recognized and accepted characteristics combined with Gypsy Blanchard's methodical manipulation of Nicholas over a 2.5-year period resulted in Nicholas's inability to deliberate at the time of the defense. A neuropsychologist with substantial practical experience, such as Dr. Wasserman, could have testified that you cannot separate Nicholas Godejohn from his autism. He is always autistic. He would have further testified that Nicholas's autism combined with Gypsy's request of him and her planning resulted in Nicholas surrendering his deliberation to Gypsy by taking what she said as fact, i.e. doing that to her mother was the only way they could be together. It was up to Nick to rescue her, yada, yada, yada. And operating as such, Nicholas surrendered to Gypsy's logic. Dr. Wasserman, or similarly situated neuropsychological expert, would have testified that these are the characteristics of an autistic person. Further support for the opinion of an expert such as Dr. Wasserman was available to counsel through information from Nicholas Godejohn's family about his behavior over the course of his entire life, as well as over the time period he was involved in an online relationship with Gypsy. From school records, hospital records, social security records, videos and Facebook messages provided in discovery, and mental health records from the county jail in Wisconsin. Information from Nicholas Godejohn's family in Wisconsin would have provided anecdotal information familiar to an expert in the field of ASD, which could have been used to support his findings in regards to diminished capacity. Okay. If counsel had investigated and consulted with a qualified, experienced expert who had substantial practical experience in evaluating and treating individuals with autism, counsel would have been able to call this expert in sub-rebuttal or rebut to the state's expert witness, Dr. Robert Denny. Okay. In a criminal case, the purpose of sub-rebuttal evidence is to give the defendant an opportunity to rebut or respond to the state's rebuttal evidence. Okay, sorry guys, I was looking at that. Okay, sorry about that. I'm coming back to read the comments. Sorry, guys. Hey, Asa. Bubble says, my sister-in-law has a master's degree in therapy for ASD, and it's a whole different curriculum. Wow. Am I getting choppy service? Are we choppy? Please don't let us be choppy. Please don't. Oh, no, we're good. We're excellent. I have my little green light on. This document, we haven't even gotten to the juicy stuff. And it's already, we haven't even gotten to the juicy shit. I know y'all wanted to get in on that juicy shit. We're going to save it. We are, how many pages are we in? Hang on 1 second. We're 76 pages in. We're 76 pages in. 76 pages in that thing. Crazy, right? $76 pages, y'all. I thought it was going to take us longer to get through that much. I feel like we've been live for maybe about an hour and a half now. Close to 2 hours. But we're going to, I know I hate to end on y'all. I know we should keep going, but we gotta have something for tomorrow. Tomorrow, We're going to pick up. We did go through a lot. I feel like the biggest thing we went through here that we got into was the reasoning behind Nicholas wanting a second trial, the reasoning behind the entire case being, going up for appeal. That's basically what I'm trying to say. The entire case going up for appeal in the way that they keep bringing up these doctors. They're saying if Nick had this doctor, they could explain certain things about him in a different way. His defense lawyers failed him in giving him a doctor that didn't really know or specialize in what he was dealing with specifically. The first 70 or so pages of this also discussed the verdict, what Nicholas was found guilty of, the fact that Nicholas and GYPSY were co-defendants. They were both charged for the same two crimes. It just went over like a lot of legal jargon in the beginning, the court timeline. It has a list of all of the state's witnesses. It has a list of all the defense's witnesses. It has a list of all the motions that were filed. But I feel like the most important thing that we've gotten into in the first 100 pages would be this huge case that they are making against this doctor in particular. The huge case they are making for diminished capacity defense for Nick, and using this doctor that they chose to defend that. I feel like that's one of the things that we did hit on. Lindsay says, I do not think legally he was of diminished capacity. I don't think so either. I did explain that earlier. I don't think he was of diminished capacity. There's some people in the comments that feel differently than we do. Not everyone's going to agree we can agree to disagree. Everyone's definition of diminished might be a little different. Oh, yes. And we also talked about, thank you, Angel baby. We also talked about the camera. They talked about the camera, how the state didn't want that camera to get into evidence, that state and that memory card of GYPSY Rose's to get into evidence. Why? What would it do to your case if that camera got into evidence? Would you be less likely to make a conviction if that camera got into evidence? If not, why do you care? It's associated with the case. Right? The state didn't want that camera in evidence for a reason. Trust me, they didn't just write that page and talk to the court and be like, we really don't, it's irrelevant for no reason. They did it for a reason. They felt as if they couldn't take their chances with there being something to sabotage their case on that camera. They couldn't take their chances with there being something to sabotage their case on that camera. And a memory card? Hell no. It's not like it was an old camera that was just abandoned there. It was most definitely probably a working camera. It wasn't some busted camera that no one's used in 10 years. It was a perfectly fine working camera in GYPSY Rose's backpack. Why wouldn't you look at it? What? You need to look at it. After all the things she and Nicholas have been discussing for the past week or two, you're not going to look at it? Hey, but let's look at the computers. Let's look at the phones. But the camera, there could have been nothing on it. But the thing about it is you need to check, right? Ace, what'd you say? Coffee? Yeah. Yeah, I can't have any coffee right now. I don't want any coffee. I had some coffee yesterday. It's just, Maybe some iced coffee. No hot coffee. It's too late. Sometimes I'll have coffee later in the day, like 5 o'clock, or like if I need some energy, like before video. But I can't do that right now. I do have a couple of videos to do. I'm probably gonna take this video down, or download it, and then put it with the other part that I had. You think there would have been a lot on it? There would have probably been some crazy stuff on there. But there could have been nothing on there. But my thing is, why is it shoved in a backpack randomly? Gypsy Rose doesn't go anywhere. Listen to me. Gypsy Rose doesn't go anywhere. The people in her area don't think she can walk. So why is a camera just shoved it down deep in a backpack if it's not in use? I'm so confused. I'm so confused. Hey, Sizzle. Hey, Sizzle. Yeah, no telling. Gypsy knows what's on there. She does. And I wouldn't be surprised if her counsel fought to not get that shit put out. You know what I'm saying? I can't speak on that, but hey, everybody has connections. You know what I'm saying? I'm not going to speak on that, but like, because I don't want to start any rumors, but her counsel don't want that out there either. Her counsel don't want any possibilities either. You know what I mean? So honestly, I think it should have been introduced into evidence. Just for the fact that it's a recording device, and all the other recording devices, that you guys sees, cell phone, cell phones, computers, all of the other recording devices that you all took had shit on it. All of them. So the camera's just exempt. It's not going to have anything on it. But everything else. Yes, Nick's lawyer was a public defender. That's correct. We're reading the FOIA documents, and yes, they were public defenders. They weren't very good ones. We were reading the case about how people believe that they didn't have qualified experts to speak. You know? No qualified experts. How you doing, Random? So, crazy world. Crazy world, man. This is good. This part got good, actually. Actually, a good read. Let me not. Okay, I just need to make sure I'm not. Showing my. Hold on. All right. Yeah, so we're gonna wrap up on here. We're gonna wrap up here. Oops, I didn't mean to do that. But yeah, we're gonna wrap up right here on page 76. We just finished this page. We're gonna be starting here, and it's gonna be going more into the doctor's testimony on Nick's autism. That's gonna go on for a little bit until we get to. Yeah, so we're going to be talking more about the diminished capacity, it seems like, tomorrow. So when you guys come back around 7 Central Standard Time, that's what we're going to be hitting up. I'm going to be taking this video down. So if you guys are looking for the replay, it won't be there because I will be taking this video down. And after I take the video down, I'm going to put it with that first part. The first part that we had where it started skipping, and then I'm gonna add this to it, and I'm gonna just post it as a video instead. But I hope you guys have a great rest of your night. It was a great live stream. Thank you guys for coming out. Thank you guys for hitting the like button. I really do appreciate it. I hope you guys have a great rest of your night. I will see you guys tomorrow. Bye now.